Hello, so today is episode 8 and I will continue to focus on WHS 156. So in the last episode I talked about, I basically read out of the opening statement in regards to that case, as it were. And now I just want to stop for a minute and also let you know what the determined issues were in that case. So the registrar got involved from the end of 2023 throughout 2024 to set the issues, because my allegations in the statement of claim were in the multiples. Being a self-represented litigant, sometimes it's difficult to keep it limited, although I thought I did a very good job. In fact, every time I go back to the statement of claims in both cases, I'm actually very happy to revisit, and when I check it, they would have been able to hold up in themselves anyway. However, the statement of issues were just there to clarify for the respondent exactly what they were responding to, and also, especially in WHS 165, I narrowed the issues down just to make it easier for the litigation to proceed at trial, because there's a lot of witness testimonials, witness cross-examinations, and they all need to follow coherently from what the allegations are. Anyway, so just sticking to WHS 156 then, that was largely unaltered. I didn't narrow much there at all. But since in the last episode, in episode 7, I did read through issue 1, which was a chief issue in regards to Work Health and Safety Act alleged breach of section 104 through to section 106, and gateway through section 112. I will now read out the issues as they were determined, and in fact after that lengthy process were set by orders by Justice Colvin on the, was it the 30th of October, 31st of October 2024, and so that was very helpful, because that meant that the parties could go ahead for a whole year before trial to really know what the fixed issues were. The issues are handy because they will then list the allegation and then the formal defence. Just coming back to episode 7, I will now just read out what the issues sounded like in regards to my experiences working for Centrelink in 2015 and 16, and what the issues actually are limited to. I just want to point out too that certainly there was no conceded allegations, there was no concessions by the respondent. Material facts were conceded as in their defence, but that does not mean that the actual allegations were conceded, and in fact by the time we went to trial there were no sub-issues that had been conceded as far as an allegation by the respondent. So the issue statement in its entirety actually just lists what I say, what I allege, and what the respondents say in response, and then the registrar had to, based on the relevant law for the allegation, would then have to sort of try and decipher what the issues for determination would be for the court ultimately at trial. So it makes it a whole lot easier for the procedure in the trial. Anyway, let me just read out. So if you remember what was in my episode 7, here are the issues. So the registrar set issues on issue 1 was based on the statement claim as it was in the format before trial in 2025. It had been changed probably about 3 or 4 times in some large ways and some minor ways, but as it was standing by the time the trial went ahead, the registrar then identifies the relevant paragraphs in the further amended statement of claim. And so issue 1, the work health and safety claim, she says, related to the paragraphs 18 through to 33, the paragraph 54 through to 56, paragraph 62 through to 65, paragraph 109 of the further amended statement of claim that was standing at just prior to trial and throughout trial. What that means is that it clarifies these are the paragraphs, these are the relevant allegations that in a nutshell drives the allegations and the claim. And from those paragraphs, those selected paragraphs, she's then gone on to identify the alleged conduct and how that relates to the acts. So as I was stating, there was quite a process in the registrar's issues process that took probably 6 to 8 months for me to really make submission after submission and also objection when it came to how I wanted to clarify my claim. I really had to stand my ground there so that the wording didn't come out completely misrepresenting my claim. You have to be very careful when you set your issues. Make sure that they are conceptualized by the registrar exactly as you envisioned it in your statement of claim. Sometimes the respondent, I think, on purpose try not to understand the claim or actually adopt confusion as a strategy, which I think is not becoming of a model litigant. As in my case, the litigant was the government. It's inappropriate. However, I would give them that much that as far as my first statement claim and then the amendments, there were many paragraphs, and as a self-represented litigant, sometimes you can mix up what material fact is and an allegation is as opposed to peripheral facts. So it was helpful, being self-represented litigant, I don't have a larger gripe with the respondent for not getting it in the first place. And anyhow, we went through the registrar's issues process, and then from there on, it was certainly very clear from August 2024 what was on the table for the respondent. So that's the benefit of having a registrar work out the issues, but you have to be very active in the process and make sure that something doesn't get missed, and also make sure that especially if you're narrowing out an allegation, that it well and truly is something that should be narrowed out by that stage, and that you're not making concessions you did not make need to make or wanted to make. So the registrar goes on to identify, she writes, registrar summary of issues for determination in Ward 156/2022. It's the work health and safety claim. The alleged conduct, she then states, the applicant alleges that the respondent breached the Work Health and Safety Act sections 104 to 106. So there she's defined the relevant law and the act. A, by altering the applicant's position to her detriment between the 24th of April 2015 and to 1 to 8 July 2016. There are a lot of footnotes just to clarify that, for instance, there's a footnote here. See, for example, para 32, 33. So she keeps writing back to the amended statement of claim. because that is what you have to do. The statement of claim is a substantive document and can never be completely omitted through the issues. If there's something unclear, you can just refer back to the statement of claim. It is a substantive document. It doesn't get traded out by issues. But especially as in my case where there was no concessions by either party, and it was basically we can just at this stage agree to disagree, and here are the issues, and as an applicant I had to be very clear about what I'm alleging, and that there had been no concessions, and the respondent then had to be quite careful about how they worded what they wanted to go into the issues. Anyway, I digress. So yes, so there are quite a few footnotes referring to the original statement of claim. So even though when the issues were set in stone by Justice Colvin in October 2024, they were said to be basically, I think he said, I can't remember the wording, overriding or displacing the statement of claim. Obviously they don't. If there's a statement claim in its latest version, it's still a substantive document. If there's anything unclear at trial or throughout the decision process or any later appeal process, you can always refer back to statement claim, and in fact that is what the Registrar is doing in my case. At this point when we were working on this, both parties and the Registrar, there was no word spoken about the statement claim being replaced by the issues. Basically this process was just meant to clarify and hone in on the allegations at this point in time. As can clearly be seen from the statement claim, she refers back to from the Registrar's issues. She is utilising the statement claim and she refers back to it many times. At alleged conduct at A, by altering the applicant's position to her detriment between 24 April 15 and 1 to 8 July 2016, and exposing the applicant to an occupational health and safety risk. And she then puts in the Registrar's note, the occupational health and safety risk alleged appears to be that the respondent did not address Mr. Bohemia's bullying, for example by stopping him from spreading rumours about her or speaking negatively about her to his work colleagues, although the applicant may disagree with his construction. Okay, so I was very clear throughout this process through the official submissions to the Registrar, and also it was actually filed to the court, that I clarified this is not a negligence claim, so hence there's no contributory effect that needs to be assessed by the applicant, for instance, by the employee, to this demise or this situation of a work health and safety risk that eventuated. So what I mean is in the Work Health and Safety Act, unless you're talking about section 19, which is duty of care, which we're clearly not, we're dealing here with section 104 to 106 and section 112. There is, we're not talking about negligence. This is not a common tort claim on negligence, and usually, as far as I understand, section 19 is not a standalone civil procedure anyway. Usually it's something there that says or confirms that there was a duty of care by the employer, but it's not a standalone section in common tort. Therefore, it was recorded at the time. I don't exactly agree with the wording here, that they should have stopped Mr. Bohemia bullying, for example, by stopping him from spreading rumours. I mean, this is not clearly worded. Of course, the Work Health and Safety Act, section 104, 106 talks about discrimination by the employer for voicing a work health and safety claim. So hence the allegation is of some omission by the employer, and basically it stops there. It doesn't need to show necessarily an ongoing, for instance, I would say this sentence almost places a responsibility by the applicant that she should have made ongoing complaints. I made one complaint, an informal complaint in 2015 around April, May, several of them, and then bullying was upheld and found in a formal HR investigation 2016. So you got a start point and you got an end point. You got an informal complaint that finalises in a formal complaint. And what I was most definitely saying in my allegation, that shows a period of detriment. So that is relating to the discrimination allegation under the Work Health and Safety Act, because the adverse act is actually that you were discriminated and that in some way it altered your position. The alteration of my position to my detriment, I was very clear in my statement claim that I call that the period from 24th April 15 through to the July 2016. I call that a period of detriment, and that's more relevant and more appropriate when you're talking about discrimination. So we're not talking about negligence, although that clearly was a case here as well. So there is an overlaying or underlying effect of a negligence claim. If you want to claim negligence, then you have to claim it within, I think there is time barred by the Work Health and Safety Act, so you have to be very careful. If you want to take a claim to the courts about involving negligence, involving a duty of care, you need to make that claim within a year of the event occurring. Clearly I'm not doing that here. This case was registered 2022, so hence I had to be very careful. This is not a negligence claim. It suffices that I made an informal complaint and that an omission was taken, and that omission was made because I was being treated as a multiple complainant or mistreated, and omissions were made because I had made several complaints, and basically that's what I'm saying is discrimination. And that is how discrimination is worded in the Work Health and Safety Act. If you go to section 104, 106, discrimination is actually just basically if the employer has altered your position to your detriment, which clearly a foreseeable risk from spanning more than a year, which was foreseeable, then you're putting, as I was saying, the employee at risk, and that's a detriment to the position, not let alone being mistreated for making complaints and ridiculed. So then we come to B, engaging in, and I allege, again, the applicant alleges that the respondent breached the Work Health and Safety Act sections 104 to 106, B, by engaging in discriminatory acts or omission by I, failing to follow up with Mr. O after he was spoken to by the service manager, we'll call her, on the 1st of May 2015. You may recall that we talked about that in episode 7. When he told her he may have some difficulty, this is a quote, I think it might have been directly out of her report, have some difficulties in managing this as some of those work colleagues are colleagues or essentially friends of long-standing 15 years or so at work. End of quote. I said is that 1? I don't know, Roman numerals. So B2, and failing to recognise or escalate the issues to management. It was not escalated appropriately. It was left as that. And he was left to self-manage, basically. And then we come to B3, and also by failing to follow up or monitor Mr. O's behaviour in or after the 1st of May 2015 meeting up to the 1st of July 2016 in circumstances where the applicant attended hospital on the 30th of July 2015 and made a further formal complaint about Mr. O on 1 July 2016, and before, failing to address the applicant's complaints properly because she was seen as a multiple or numerous complainant and believing the applicant's multiplicity of complaints were not in good faith or for a proper purpose. And C, taking the action for a prohibited so just dealing with those subheadings there. Failing to address the applicant's complaints properly, that sounds good enough. The previous one, failing to follow up or monitor Mr. O's behaviour in circumstances where actually attended hospital shortly after the first complaint. Failing to follow up or monitor Mr. O's behaviour, it's worded like that, and I think it's good enough. But basically, the actual omission act is what happened on the 1st of May 2015 when he said he may not be able to stop his behaviour. Then an appropriate action, a follow-up of some sort of a follow-up should have been set. So it's not necessarily, again, this claim doesn't broach on to a negligence claim, failing to follow up or failing to monitor his behaviour or failing to stop him bullying. That is coming more into negligence, and I have been very clear about this, and that it's not negligence. It's not about a continuous monitoring. It's about taking appropriate action from the 1st of May 2015 meetings. You have to be very careful not to go into negligence getting confused about this being a negligence claim, because it's not. It is a discrimination claim, and it points to one point in time, and it's all about a specific period, which is the 24th of April 15 through to the 1st of May 2015. That is where the omission and the lack of action or the wrongful action was taken. As I'm saying in my claim, is that the rest was a detriment period, because the claim is about an alteration of my position to my detriment, and that the case law has said can be just about anything that's detrimental to an employee's position. And so definitely an aspect of that is the mental illness, ending up in hospital, and etc. Anything detrimental, whether it's work conditions or whether it's the health of the worker, is basically an alteration to of the position to the detriment. But I think especially, as I was saying, that there was a very known, a foreseeable risk from the 1st of May 2015. So this is where one has to be very careful how it's being worded. And that's probably why it was so difficult to get this clarified throughout the early submissions, and that's why we went into the Registrar's issues process, because this had to be nutted out, as they say here in Australia. A lovely day here, last month of summer, and it's going to reach 37 Celsius degrees today, and we're going to have a projected 40 tomorrow. Now, as I was saying before, the issues were not conceded. Basically, the respondent did not engage in any way, shape or form until the registrar set the issues. It was very, very difficult to get the respondent to acknowledge that they understood anything about this case. So then the registrar was just forced to say, well, the applicant says that, and I'll read that out, and then the respondent says that. And so at least it becomes clear on paper. So then she's formulating that the applicant says that the conduct by the respondent gives rise to a claim pursuant to Section 112 of the Work Health and Safety Act. And B, that her claims are not statute barred by Section 113 of the Work Health and Safety Act, because she only pleaded her claim under Section 104 and 112 of the Work Health and Safety Act in her amended statement of claim. So that's what they call a FASOC, further amended statement of claim. around 23rd February 2023. So 6 months into the first application, the application being made. The further amended statement of claim introduced a work health and safety. I had to take out section 19 because I'd made a mistake, but also through the discovery process I then took possession of, through the respondent, the actual HR report where I found out, where I could see the report by the service manager made from the meeting with Mr. O on the 1st of May 2015, and that is where I discovered that they'd actually spoken to him and he said I might not be able to stop this behaviour. Then I started looking at the different sections of Work Health and Safety Act, and lo and behold, section 112 is the gateway where you can apply for a discriminatory case for raising work health and safety issues, and the time limitations different on that. I've broached this before. It's when you became aware of the omission or the action, and I only became aware when I took part of the HR report in 2023. Therefore, I argue it's not time bar. Usually time bar is 1 or 2 years. I think now it's 2. Back then when I listed a case it was 1 year. So you have to list a case within 12 months of becoming aware of the action or omission. And so when I listed a new statement claim and introduced Work Health and Safety Act section 104 to through to 106 as the gateway, using the gateway of 112, that was well and truly within 12 months of finding out the omission had taken place. And so the respondent, as I will say later, as I will read later, thinks that this claim is time barred, and I'm saying it's not time barred because I only became aware of the very specific action taken, or certain amount of actions taken, when I took part of the report, which had been buried and denied me. So she says, the applicant says her claims are not statute barred by 113. This is a time barring section of the Work Health and Safety Act, section 113, because she only pleaded her claim under, I did read that, 112 in her amended statement claim around 23rd of February 2023, and leave was granted on the 8th of March 2023 to amend the statement claim to include a Work Health and Safety sections as mentioned. And as she only became aware of the Work Health and Safety Act claim on or around 31st of October 2022, when she received the response to a notice to produce from the respondent, which revealed the contents of the respondent's internal HR investigation and notes of the respondent's discussions with Mr. O, in particularly the 1st May 2015 discussion between the service manager and Mr. O. And C, the applicant says her claims are not statute barred by, that was one that was an overlap with Fair Work claims, but that's part of the Registrar's process. I took out some intermingling Fair Work claims from this claim because they were covered by WHS 165. And you can't claim something to have happened under Work Health and Safety Act at the same time refer to the same actions under the Fair Work Act. There is such a situation is barred by section 115 of the Work Health and Safety Act. You've got to choose either a claim under Work Health and Safety Act or the Fair Work Act, either or, in relation to the same events. So the events of 15 and 16, I have chosen, obviously, to go through with the Work Health and Safety Act and not the Fair Work Act. The Fair Work Act itself has a time barring of about 6 years, and in 22, Fair Work Act would have been time barred if I'm talking about something that happened in 15-16, just outside the 6 years. So I'm saying that the work health and safety claim is not time barred under section 113 because it's basically when you became aware of the omission, aware of the discrimination. So although I was aware of the actual behaviour by Mr. Bohemia, Mr. O, this is not what we're talking about. This is a claim against the employer. Mr. O was not a co-respondent in this claim. So it's, once again, it's not about negligence. It's not about his behaviour, although his the serious misconduct and details of it will then become evidence in relation to my injury, because that's a detrimental alteration of my position, is that I suffered pain and suffering and an injury, but also basically it was an untenable position to be in, so very foreseeable, and it could have been managed, this situation, right from the 1st of May 2015. So what I'm saying, it never should have happened. Now the respondent, as I said before, they do say that the work health and safety claims are statutorily barred because the claim is barred pursuant to section 113 of the Work Health and Safety Act. So they're saying I commenced proceedings on the 27th of July 2022, so that's when the application in WHAT 156 was made. That's more than 1 year after the alleged contravening conduct in 15-16. And then they go into detail things about that statute barring, but what they have completely decided to disregard is the fact that the statute barring of section 113 says very clearly 1 year or when you reasonably became aware of the omission and the action. So that changes the goalpost substantially for the statute barring. They have not addressed that. They've never addressed the fact that I became aware from their own discovery process they partook in, where I requested discovery, requested the report, which had previously been denied by Freedom of Information process. So when I listed the cases in the federal court, I was able instead to go through the discovery process, and it's almost like a subpoena process. So I then was able to see the whole HR report, and that was not, they sent it to me in October 2022. I read it on the 13th of January 2023, after Christmas basically. Who would want to ruin the Christmas by reading all the details about what Mr. O did to me? So I left it for a little while, until well and truly after Christmas. So even at if we take the 13th of January even if we take the 22nd of October 2022 as the earliest time I was made aware, reasonably made aware, then it's well and truly the case was well and truly made within 12 months. Now, the case was applied for in 22, but the respondent did not object to the statement of claim being altered to include a different section of Work Health and Safety Act. So the claim was shuffled in by myself in an interlocutory process of where the statement of claim was altered to include Work Health and Safety sections 104 to 106 as made possible by section 112 purely by alteration of the statement of claim in 23. So that was post discovery. At any rate, the Work Health and Safety claim was included well and truly within 12 months of becoming aware of the omission by the employer. So in this case there were a few changes of the statement of claim. Never an ideal thing, but it does happen quite often, and I was very lucky that I was able to get my statement of claim altered. That is not very easy. I had to be very clear, and I was very lucky to have that accepted, and once it's been set in order, there's no going back. So that is the statement claim, and that included the Work Health and Safety Act. It's almost like it was a new application, but there's no need to make all these separate and different applications, and I think that may well have been what Justice Colvin accepted as well. At any rate, I was able to include it after the discovery. So they're also saying that the claim is barred in itself pursuant to Section 115 of the Work Health and Safety Act, because I had commenced proceedings in relation to the same matters under the Fair Work Act. Now, there was some shuffling just before, well, in the Registrar process, where some statement claim paragraphs were dropped so that we wouldn't have the clash between the Fair Work Act and the Work Health and Safety Act. So I think that concern and that protestation was actually fell away, because I did take out a few of the Fair Work Act, extraneous Fair Work Act allegations that I did have in relation to the same matter. Because in those early stages I had not quite understood you couldn't drive the claim under both acts in relation to the same evidence, the same matter. So 1516 events wholly in WHS 156 comes completely under the Work Health and Safety Act. There's no intermingling with Fair Work Act. There are other issues in that case that relates to 2017 and 2016, where I did use the Fair Work Act to make allegations of certain actions there, which I'll come to. There are the other issues, but they were within the 6-year time frame, and they're also not relating to events specifically in relation to 1516. So there is, I think this issue fell away completely in that there is no time, there's no material barring on Section 115. There was no intermingling on issues with Fair Work Act and Work Health and Safety Act. Now, the respondent also admits in this issue statement that in 2016 another service manager conducted a preliminary investigation and found that in Skype conversations with two of Mr. O's colleagues on 29 to 30 June 2016 and 5 to 8 July 2016, Mr. O made remarks about the applicant that amounted to bullying. So here they are accepting the misconduct finding, and that it was in fact a HR report of a formal nature that was made in 2016. I mean, how could you not admit that? This is an admission of a material fact, not an admission of an allegation. Have to be very careful to discern between the two. So they are obviously just admitting that the HR report exists, but they do deny that the respondent's conduct breached the Work Health and Safety Act. And so the registrar finishes by then saying, well, what are the matters to be determined in this case by the court? Insofar as issue 1, we've only up to issue 1, which is a chief issue of this WHS 156. So the matters to be determined by the court is whether all or part of the applicant's work health and safety claims are statute barred pursuant to Section 113 or Section 115 for that matter, which I said fell away, of the Work Health and Safety Act. So this is the big question in this case, is that is my claim actually statute barred? Will the court accept that I only came across the and became reasonably aware of the action, the discrimination action by the employer when I partook of the HR report, which I was very careful to state in my affidavits about how my efforts through the Freedom of Information had been unsuccessful, and how the report was not provided to me at the time of the upheld complaint, the formal complaint. and the freedom of information was unsuccessful for several years. And I really did, in fact, only find out about the what Mr. O said in that first May 2015 meeting. I only found out reasonably, I admit, reasonably, when I took part of that discovery or that HR report sent to me in October 2023. And then I listed that additional case as an ad hoc to my statement claim in around March 2023, which is well and truly 12 months within the reasonable discovery. So that is a big one for the court, and that's going to be a landmark decision. There's almost none such situations in Australia where someone has used Section 112 to gateway a discrimination case under the Work Health and Safety Act so many years after the event took place. This is certainly going to be a landmark decision, and I can't wait to see what the court decides. I think the evidence speaks to my case in favour, especially as I did provide an affidavit with the all the declines by the Freedom of Information to request this report. It's very clear in the evidence. I had no idea what was told to what Mr. O said in that meeting, that he may not be able to stop talking about me to his colleagues. And in that first complaint, I had very clearly stated he's very likely talking about highly private or embarrassing or slanderous or filthy matters, because that was the in fact the complaint in 2015, that he was talking about that sort of matter at work, including sharing photos and text messages in our relationship with his colleagues. I think that's there in the evidence somewhere. So when he said he may not be able to stop, and there had been several incidents of him intimidating he might not be able to stop, then that was on the cards in May 2015. So when he said he may not be able to stop, that is what I'm saying. That was a foreseeable risk. They took no action, nor did they let me know to say, for instance, look, this is what he said, so if something happens, let us know straight away. Instead, they told me, as I said in episode 7, that they told me that the matter was closed and resolved. He had been spoken to, the matter was resolved, and that was not clearly the situation. So, where was I? Now, the registrar says that if the claims are not statute barred, then we have some real issues to deal with here. So they have to decide whether the respondent engaged in the alleged discriminatory conduct defined by Section 105 of the Work Health and Safety Act. So did they make this omission because they felt like I was a multiple and useless complainant and not to be taken seriously? Basically, that's discriminatory conduct for having raised work health and safety claims. When I say work health and safety claims, I mean bullying complaints. And there were several of them by the time the 1st of May 15 came around. And as you can see in episode 7, it was joked about in management about the situation. One team leader joked that she was a 000 number for my complaints. And also what needs to be determined is whether the applicant had raised an issue or concern about work health and safety by making complaints for the purpose of Section 106 of WHS, the Work Health and Safety Act, which clearly I had. That's on the evidence. And also whether the respondent took the discriminatory conduct substantially because the applicant raising the issue or concern. So was it for a prohibited reason? The prohibited reason on the Work Health and Safety Act, discrimination was I discriminated for a prohibited reason? So was the discrimination or the mistreatment or the omissions made because I had made complaints, bullying complaints, which is what I actually allege, because there were several complaints at hand by the time May 15 came around. So this is what this concludes issue 1 on the statements on the registrar's issues, and I was reasonably happy with that, how that was portrayed in the issues. It clearly identifies the Act and the sections, the conduct, what I say happened, and also what the respondent says happened, and then what the matters to be determined by court definitely engages with all the elements requirements of section 104 to 106 and section 112. It identifies that we need to assess the time barring under section 113, which is very much in dispute. So the registrar has actually covered all the relevant issues, and because they were set in stone by an order in October 24, a year later, when we were then making our final submissions before trial, and then the opening statements and closing statements, there's no question about what was being fought out at the trial, which is the benefit of having set the issues. Because if we were to just go by my statement claim, I think I had about 80 or 82 maybe paragraphs in my statement claim, and you need to be very, very clear about what is being said and how it's being defended, and with the issues in place, there's no question about how to dress the witness statements and the submissions based on this skeleton set of issues rather than the statement claim. Although, like I said before, if there's anything that's not clear, you can always go back to the statement claim. It's a substantive document. It can never be traded away, unless you actually trade away whole allegations. And before the registrar, there was narrowing. There were other allegations that were taken away, but not the chief ones. So hopefully that makes sense. That says something about the benefit of the registrar's issues and how you set them to everyone's benefit, especially the applicant, and even more so the justice, who has to sit and siphon through where to identify arguments and evidence. So extremely important, but it's also very important that if you have to go through as a self-represented litigant and have to go through a registrar's issues, then most definitely you have to be very, very clear about making sure that the registrar gets the issues very clearly. Doesn't have to be perfectly worded, but in the best legal expression possible, bearing in mind that the registrar may not be necessarily legally trained or a justice. You have to give you have to work with them. If you're a bit more clear on the legal wording, you have to be quite assertive about getting the wording right. Alright, so that concludes issue 1. So I spoke about that in episode 7, and here was the registrar's issue on issue 1. So that concludes this episode. Thank you.